You've been arrested for DUI, and you're wondering whether you're going to go to jail and lose your license. You should be concerned about both of those in this situation. But first, in the state of Georgia, your driving privileges and going to jail are actually separate proceedings. In a DUI case, you actually have two matters. One of them is with the Department of Driver Services, and they determine whether you have driving privileges or not. The other is the criminal courts, the ones that are more familiar to people, where there are juries and so forth. And they determine whether you go to jail or not. As soon as you are arrested for DUI, one of the initial things that you must do immediately is either contact counsel, or if your license was, if you were given a suspension notice by the officer, you must file an appeal of that suspension. That is the first thing you do to save your license. The next thing that you must do is, once you've bonded out of jail, an arraignment is actually going to be set up. You need to either make a decision to go with a public defender or to hire counsel prior to that arraignment, because at that arraignment you're going to be expected to give a plea, and immediately following that plea there are motions and things that have to be filed that assert your defenses. You do not want to sit back and wait and not hire counsel prior to the arraignment. So the answer to the question of whether you're going to lose your license or whether you're going to jail is really determined by, one, the facts of the arrest, but two, whether you decide to retain counsel who can aggressively fight the DUI on your behalf.